Hey, actually, Pepper's replacement is with us today. I hope. Have we started live yet? I'm sorry.
Not. We are now streaming, John.
Okay.
Good morning, everybody. It's Thursday, May 6th, Senate Judiciary. We're in extra innings. We officially closed the committee last week, but we have permission from the pro tem to do a couple of meetings this week and a couple of meetings next. This morning, we're going to be looking at House amendments to S3, possible House changes. And we've got Eric Fitzpatrick to walk us through that. Morning, Eric. Do you want to
Senator Brew?
Do you want to share your screen?
Yeah, absolutely. If the committee's okay with that, I think that would be the most efficient way to see what the language differences are between the bill that passed the Senate and the bill that the House is, well, actually it hasn't passed yet, but the House is working on.
What does their timing look like?
I heard, again, these things always are moving targets this time of year, but I heard that they thought it might be on the floor tomorrow.
Okay.
But, you know, that could always change.
Yeah.
So shall I share the screen now? Does that make sense?
Go ahead. Are you a co-host?
I think so. Yep.
Okay. And Senator Sears will be with us. He's monitoring right now. He's taking care of a few things and he'll be with us momentarily.
Does everybody see this document that highlighted at the top says House changes to sections 1 to 5?
Yep.
Yes.
Okie doke. So for the record, it's Eric Fitzpatrick with the Office of Legislative Counsel here to walk the committee through the proposed change that the House is making to S3, which is an act relating to competency to stand trial and insanity as a defense. I'm sure the committee recalls, having spent a lot of time on this, that this bill has many different provisions related to the statutory procedures that are mandated when a criminal defendant is either raising the issue of competency to stand trial or insanity as a defense, or has been found incompetent to stand trial or insane at the time of the offense, and the procedures that follow that finding. So there's a lot of different provisions within the bill that are related to those procedures. So I think as I walk through them, I'll kind of take a moment and remind the committee of what's being talked about in each section. So I'll jump right in. Section 1 has to do with the examination of a criminal defendant's competency or sanity at the time of defense that the court orders whenever the issue is raised, whether it's raised by the defendant in the context of raising an insanity defense or by the court or one of the parties with respect to competency. But when the issue is raised, then the court orders an independent evaluation of the person to get an independent psychiatric evaluation of the person's mental health status. So what you recall had been happening in section 1 here as it passed the Senate was that, and this sort of turns on the issue of, you may recall the point that competency to stand trial and sanity at the time of the offense are two different things, two different evaluations, two different moments in time that are being evaluated. And so what section 1 did was it made sure that because the language, the statute on the books seemed to suggest that the evaluation always had to evaluate both competency and sanity, but that doesn't comport with what actually happens or the reality, since competency and sanity are two different things, and sometimes one is raised but not the other. So the language is clarified as the Senate passed it to make sure that that the evaluation can evaluate competency or sanity or both, and that's lines 1 through 15 there. But and it sort of related to that is the fact that, and this is something that was added by the House, is that as it happens, when a person's sanity or competency is the result of a mental illness, then that person's evaluation is conducted by a psychiatrist. However, it's also provided for in the statute that a person's competency or sanity can be the result of something other than a mental illness. It could be a developmental disability, for example, or a traumatic brain injury. When that's the case, we'll see later on, a couple of different things flow from that. And one is the one that you're looking at right now, is that when a person's competency or sanity is may be the result of a developmental disability, then there's a specific statute that already exists that says that this evaluation also has to be done by a psychologist with expertise in developmental disabilities. So in other words, although the existing provision is correct that it's only a psychiatrist when it's a person whose condition is the result of a mental illness, a couple of changes were made here to make clear that, well, that's true, but additionally, there has to be a psychologist with expertise in developmental disabilities participating in the evaluation if it's a developmental disability that's being raised. So that's what you'll see this repeated several times right here. This language you see on lines 20 and 21 about the evaluation. It's conducted by the examining psychiatrist, and here's the highlighted language. If applicable, so it's going to be either a psychiatrist, that's line 20 existing, and if applicable under section 4816B, and that's the statute that I just referenced that says specifically, if it's a developmental disability, it also has to be a psychologist. So this is just roping that in. If section 4816B applies, then it's the psychiatrist and the psychologist.
Eric,
So, yes.
just the word "or" is struck there.
Yeah, I'm wondering the same thing.
It shouldn't be struck. Am I correct?
I believe that's correct. Well, I think it should be. Yes,
I mean,
well, it's funny because there was a lengthy debate about whether it should be or and in the House. But yes,
Yeah.
I think you're right. Or is what it should be. Thank you.
Okay. Let's keep going.
Yep. Let's see. So you may also recall, so the report that is generated after this evaluation, you may recall that one of the provisions that was added in the Senate bill was, because there's an existing list, I'm on page 2 now, lines 2 through 7, of who gets a copy of the report. And the Senate had added line 5, the Commissioner of Mental Health, which makes sense, right? Because the department is very much involved in these proceedings, and if the defendant may be committed to the department's custody, so it makes sense that they would get a copy of the report, and that's what the Senate added. 2 more parties were added by the House to get a copy of the report. Line 4 is the respondent, that's the defendant, so the defendant, him or herself, would also get a copy. And then line 6 or 7 of the Department of Disabilities, Aging, and Independent Living. Now, this is connected to the point I just made about developmental disabilities. That's because the other consequence that could flow is if the person's lack of competency or sanity is the result of a developmental disability, then the person would not be committed to the Department of Mental Health if they're found dangerous. Rather, they are by statute, they are committed to the custody of Dale. So it would make sense that, as you see the way it's written, and if applicable, then Dale gets a copy of the report. So in other words, I think, as everyone understands, that means if it's a developmental disability that's involved, then since Dale would be the person who would potentially get in custody of the person, then they would also get a copy of the report in that instance.
Mm-hmm.
The next provision involves, remember, the issue, and the committee had discussed this as well, that what happens when, as we're talking about, the fact that competency and sanity are two different things. And as we looked at in the previous section, the evaluation does not have to evaluate both of those issues, but it could. And so this provision, remember, dealt with exactly that instance. So what if the court does order? What if the psychiatrist or psychologist has been asked to provide opinions as to both of those things, both competency and sanity at the time of the offense? Well, the Senate passed language, and this is lines 8 through 15, provided that if that's the case, then the report has to address both of those issues separately, and they have to be presented in separate reports, which again makes sense because as we're talking about, they're two different things. And it went on to say, this is lines end of 11, 12 to 15, that the examination of the person's sanity would only take place if the psychiatrist, or again, this is that language I mentioned earlier, a psychiatrist, or line 13, if applicable, the psychiatrist and the psychologist, if they're able to form the opinion that the person is competent to stand trial again. And that the idea of that is that, sanity is a defense that the defendant would not be raising if they're not found competent to stand trial in the first place, because in order for the proceeding to go forward, there has to be a finding of competence. So if that never happens, if the defendant is never found competent, then the sanity issue would never come into play. The defense would never be raised. So it makes sense both in terms of logistically and efficiency of resources that, you wouldn't do this sanity evaluation if it's never going to be needed. So that's why that language was in there as it passed the Senate, to make clear that the sanity evaluation doesn't happen until competency is established. So what the House added to that is you see highlighted in lines 15 to 21. And the first piece is, you see that's sort of a clause, lines 15 and 16, adding on to that point that I just made about the timing of the evaluation. Says, yes, okay, that the provides the defendant with the opportunity to request that they occur concurrently. So yes, generally speaking, as you provided in your language, sanity evaluation doesn't happen until after competency is established. Line 15 highlighted though, unless defendant requests that they occur concurrently. So provides the defendant with the option essentially. And that's based on the ABA, the American Bar Association, has some model language on this that's very similar to what you passed in the Senate, but it does add that provision. It recommends that the defendant have the option to request that they occur concurrently, and that's what that is based on. The last second sentence addresses the point that if you think about the situation in which the sanity evaluation is delayed. So let's say, it doesn't happen at the time of the competency evaluation, as we've just provided for here. You said, look, the two things are separate, and sanity evaluation doesn't happen until competency is established. So in that instance, if you think about it, it could be quite a long time before the person could be going through years of treatment before to establish competency, and it might take quite some time. And if the sanity evaluation doesn't happen until competency is established, that could be years after the offense, or quite some time, whatever it may be, after the offense was actually committed. And so I think the concern discussed in House Judiciary was, well, might there be loss of evidence during that time? Might their people's memories not be as good? People tend forget things over time. It's natural. So they provided for language here that would require the psychiatrist or psychologist, whoever's making that evaluation, that if that happens, if you see in line 16, if the evaluation of the defendant's sanity doesn't occur until the defendant is deemed competent, if that's the case, then skip down to line 19. Psychiatrists and psychologists shall make a reasonable effort to collect and preserve any evidence necessary to form an opinion as to sanity if the person regains competence. So the idea is at the time of that competency evaluation, even though they're not doing the sanity evaluation yet, they still make a reasonable effort to preserve any evidence that would be helpful and necessary for the sanity evaluation if that ever needs to be done in the future.
Eric?
Nice.
Yes.
Go ahead, Alice.
I'm just wondering, can you review just briefly how that piece works right now, or something relatively similar to this? What happens presently in terms of the psychiatrist and the psychologist, or don't we ever have the psychologist in there?
No, I think it does happen presently. The statute requires that a psychologist be involved if it's a developmental disability situation. So they could both be involved. I think presently, I think some of the witnesses you have today certainly could correct me on this or have more experience with it. But I think presently the court orders the evaluation to take place when sanity or competency is raised. A psychiatrist is chosen by the department, I believe, and conducts the evaluation. And I think as far as whether the timing of it currently, in other words, because of the way the statute is worded currently, it seems to require that both evaluation and competency, that sanity and competency are always evaluated. I don't know if in practice that happens. I don't know if in reality they only evaluate competency, if competency is the only issue that's raised. I'm not sure. That might be a good question for a witness.
Okay, thanks.
Okay, and Eric, I have a question that maybe jumps off of that. So we were talking about conservation of resources, and that was part of the impetus to separate out the two examinations and only to perform the second if necessary. But in this new language, they have to make a reasonable effort to collect and preserve any evidence. So my question is, do they do that now? And if they don't do that now, to what extent does that involve the resources that we're trying to save if it's not necessary? Does that make sense?
It does make sense, but I don't have any answers to those questions.
So
sorry.
Another one for the witness.
Right.
Oh, okay. All right. Well, let's, unless there's more questions, let's move on.
Okay. Just pausing for a moment in case anybody wants to jump in.
That's all right. We can ask Alice's and my question of them when we shift over to witnesses.
Oh, okay. Sounds good. So moving on to the next section, then this has to do with the hearing regarding commitments. So we just were talking about the evaluation that has to take place when sanity or competency is raised. This is, if you think of it sort of further down the timeline of the process, the court has to, if you presume that a person, there has been a finding that the person was either insane at the time of the offense or incompetent to stand trial, then the next thing that has to happen is the court has to hold a hearing to determine whether or not the person is a danger to themselves or others. And if the person is found to be a danger to themselves or others, then they have to be committed either to the Department of Mental Health or, and as you see here, line 3 and 4, page 4, if applicable, remember I mentioned this earlier, they would be committed to the Department of Aging, Disabilities, Aging, and Independent Living if it's a developmental disability situation. So what you had done here was that when it passed the Senate, you provided that remember, I'm on lines 1 and 2 now, top of page 4, that the person is entitled to have counsel appointed by Vermont Legal Aid. So they're going to be represented by legal aid if they choose. They could also choose to retain their own private attorney if they wanted. And then you also provided in the second sentence that DMH would also be entitled to appear and call witnesses. So consistent with what I mentioned earlier, which is that it's potentially the case that Dale would be involved here rather than DMH. If it's a developmental disability case, this provides that DMH and, if applicable, Dale will be entitled to appear and call witnesses.
Am I remembering right, Eric, that we got rid of, wasn't there originally a provision that said the AG's office represented DMH? Or-
Yes, I think there was originally. Yeah,
And we took that out on purpose.
correct.
Yeah, okay.
Hmm.
Okay, so that's just truing that up with the other place where we added Dale.
Exactly. Exactly.
Can I just ask another question?
Yeah, go
Which-
ahead.
I realize this is not changing, but does and I don't know this about Vermont Legal Aid, but are they, I realize we want them to be involved. That's great. But I'm wondering, under Vermont Legal Aid's own provisions, can they represent very wealthy people who have the ability to represent themselves? Is that an issue for them? I'm sure, or, well, when we get to them, I guess I could ask.
Yes,
Yeah.
I think the witness will be better able to answer that question. Exactly.
Yeah, and I think we also added money to Vermont Legal Aid in either budget adjustment or this budget. to
No,
cover-
actually, we took the money out, and because of the status of the bill, we didn't put it in, I don't believe. I checked with Stephanie and Jane, and I don't believe we put it back in because we weren't sure of the status of the bill. And I know that the bill will, assuming it passes out of House Judiciary, it's going to head to appropriations.
Okay. And we can take care of it there.
Yeah, they would have to. But I think we might have added something to Vermont Legal Aid for this in other areas, but I'm not sure about that. I know we didn't add anything to DMH.
Okay. Okay. Is there more, Eric?
Not in that section, but there's more going forward.
Okay, let's keep going.
Okay. So we're now moving into the section that has to do with victim notification. Remember, that was also a big issue in this bill, and you'll see the provisions that I'm first mentioning here weren't really changed. And this was the idea that that when after the defendant has been committed to the Department of Mental Health, sometimes the status of the defendant will change, right? For example, the defendant could be released after treatment has been completed. Could be that the defendant would be stepped down in treatment level from inpatient hospital treatment to non-hospitalization treatment, which would occur in the community. It could be that the department would just not opt to renew the commitment order, in which case the person would be released to the community. So in all those situations, what had passed out of this committee and the House Judiciary Committee did not change this, was that notice would have to be provided when the defendant, I'm just moving right to the language right there, when the defendant's status changes in that way. You see, for example, lines 8 through 17 or so, that's the situations when notice has to be provided by the department to the state's attorney or the attorney general, and then the SA or the AG has to in turn provide notice to the crime victim that this change in status of the defendant is happening, so that they'll know when the person is released into the community by any one of these methods that are identified here. So the changes here are really, the first two anyway, are really technical. You see number 10 is just a language change because that's the way the mental health statutes say it. They're discharged from the hospital, not discharged from commitment in a hospital. Second one is line 16. You'll say also, that's also just a terminology change. It's the same concept, but I guess the mental health statutes use the word elopes. They don't use the word absconds. So that we're just truing that up with the language that's used in that area of the law. The last one here, you'll see this is about again, the notice to the victim, and the way the change is words that have been added on line 20. This is one of those situations where, and I testified to the House Judiciary Committee on this point, that, and this sometimes happens in the legislative process, I didn't see any legal need for this language to clarify that the victim of the offense, it's the offense for which the person has been charged. But on the other hand, it doesn't hurt anything either. So I think for clarity, the House added the language, as well as just making clear that that it was the victim of this particular offense. That's the person who's getting the notice.
Okay. Dick, you're muted.
I know. I said in appropriations, that'll be on my tombstone. Dick, you're muted. Would that confuse things if there were multiple victims
Oh,
of different crimes?
I don't think so, because it's the crime. It's the highlighted language is talking about the defendant, not the victim. That's
Frequently state's attorneys will, lower the crime or drop one offense and because they can get a deal on another offense and blah, blah, blah. I don't know if this happens here. If you don't think it's harmful, I guess I'm okay with it. It just is a little bit of a weird thing. Which kind of just keep that in the back of the mind, and as something that if we were to concur with further proposal amendment, that's one place where I would say we'd probably want to remove that language.
sounds good. I'll note it.
Thank you,
All
Eric.
right. Yeah, sure. I'm just jotting it down here. All right, so we entered the elopes, we did that piece, which we're noting for possible removal. Okay, so now you're coming to, this is a section that was removed in the House, and it is also related to the victim notice, but remember, this is a separate notice. And it's not the one that we were just talking about where the defendant's status changes, their treatment status changes or treatment is completed and then notice is provided. This has to do with a separate situation when the defendant is in the community already on an ONH, an order of non-hospitalization. So the defendant's being treated in the community, and then it becomes clear, you see lines 9 through 11, that the defendant's in the community, but they're not either not complying with that order of non-hospitalization, or this alternative treatment, whatever they're getting in the community, is not adequate to meet the person's treatment needs. Now, if either one of those things happen, then this language requires notice again. So notice is provided to the state's attorney and attorney general. It doesn't require victim notice after that, but it does require notice to the state's attorney and the attorney general. You remember this particular piece had been discussed quite a bit in this committee, and because there was some debate back and forth about, well, what circumstances, what does line 9 really mean? What does line 10 through 11 really mean? So, there was discussion about what circumstances really would trigger the requirement that the department provide this notice, and secondly, what would the state's attorney or AG do with the notice once they got it? What's the appropriate thing? So you may recall that in addition to putting this language here, you also included language that would study those two issues in the forensic work group. So you put it in both places. You put it here, the requirement that the notice be given, but recognizing that there was still some issues that had to be fleshed out, you also asked the forensic work group that's established later on to look at those issues as well. So what happened in the House was it kept the provision that the department look at the issue, but got rid of it in the statutory requirement that you're looking at right here. So this piece of notice was removed and they kept it in the, essentially in the study concept that they would look
Eric,
at that.
Yeah, no, I understand what they did, but this is at the heart of the case. A case like Pronto, the one who's accused of murdering the girl on Martin Luther King Day, slashing her neck and killing her in downtown Bennington. And this, he was frequently under DMH, under the local mental health center. And one of the things that Erica Mathich, I think, spoke about in her testimony repeatedly was that she had no idea that he was failing. If this was a person on probation or a person on conditions of release, courts or the police would notify the state's attorney immediately. This guy was on video saying, I'm getting away with anything. I can do murder if I want. And, you know, he was terrorizing a neighborhood and they didn't do anything. There was nothing done because, you know, he was on non-hospitalization. I think if you go back and think about the testimony that we heard from both Erica Mathich and the mother of Emily, it was compelling that this, whether you know what to do with it or not is a good question, but at least you're aware that this guy is not, you know, participating in any form of treatment. And so I'm disappointed that the House took this out because this is a key area of notice, at least the state's attorney's aware. So anyway, for me, this is a key area.
May I comment on that?
Sure.
I actually agree with this change. And the reason is because I have always thought that this was way, way, way too subjective, leaving it up to the therapist or the caseworker or whoever is working with the person. If they don't show up for one meeting and the therapist just doesn't like them, they could report it. I think studying it is a really good idea, but I've always felt that this is too subjective and open. Just my feeling.
Okay.
And I know it was a real issue in that case. And I don't know how we do that, but I hate to do any kind of legislation or changes based on an incident or an event. So
I've lost a lot of faith in the system, quite frankly, over this. And what I've learned, we bring it up tomorrow on 225, the Butte bill. But what I've heard from people in emails and people that I know who've sent me emails, I'm losing faith in the system that's really not responding to the problems. We can get into that tomorrow. I highlight this as an area, but if the committee wants to continue to study it, I understand that, you know, I don't know what the state's attorney does with this information or the victim does. At least they're aware.
Right.
yeah. And
I understand your concern, Jeanette. I mean, I've had situations like that. If you go back to the guy that wasn't guilty of rape, was in prison because he wouldn't admit he raped the girl. And even though he would have been eligible to be released, I mean, I don't know if you remember that testimony. The guy from the sergeant in the Army who was accused and convicted of raping a girl that he didn't rape, but he never would admit it. So they kept him in there because he was considered non-compliant, and they did a mental health order that he wouldn't admit. So, I can't remember.
Well, I may be the only one that had concerns about that in the first place.
Yeah.
And I just think it's so subjective. The caseworker doesn't like the person, they're screwed.
So what did they put in to replace this? A study?
Nothing. Study.
We had it in the study already.
I'd like this section to stay in or something similar.
We can come back to this if we do concur with further proposal amendment, assuming that it ever gets out of House if it ever gets out of House appropriations, I don't know. Once it goes there. You know, don't forget, we passed this bill a year ago and the House never took it up. I mean, I don't want to get hung up on this section because there are so many important things in this bill that ought to be dealt with. We have a system in crisis, and instead we worry about other stuff. Okay, go right ahead.
Okay. So I think that's it, other than the studies, which I'll get to next. Section 4, there were no changes to this. You remember, this is the language that permits the prosecution to ask the court for a mental examination when the defendant raises competency as an issue, the same way that existing law, which you see in lines 1 to 4, permits the prosecution to ask for that when sanity is an issue. So no changes to that section. So now we're getting into the reports. I don't know, I'm just going to check since I don't have my screen up. These sections were dealt with by the House Healthcare Committee. And Katie worked on these more than I do. So I'm just asking if she's here. I know she's here, then she could take over, but if not, I can certainly give it a shot.
Section 5 looks like it has, you know, only extended for, the reason we put in November 1st, is because the Senate can't introduce legislation after a certain date in December, and the House can. Katie, maybe you want to take over?
I'd be happy to. Good morning.
That's the only reason. I mean, that date doesn't bother me, except that we can't introduce legislation.
So Katie McLean, Office of Legislative Counsel. You'll see the version that Eric has the changes from the House highlighted. But just to kind of remind you what this section was about, the version that passed out of the Senate had an assessment of the mental health services that were being provided in correctional facilities. In particular, the evaluation was to look at how services in correctional facilities compared to those provided in the community. So you'll note on the first line, there's the date change of when this work is due. But then when we scroll down to subsection B, Subdivision B1, you'll see that in Subdivision B1, we're retaining that concept of comparing services in correctional settings to those available in the community. And then the House added language that recognizes the comparison to currently available services doesn't establish kind of the best standard of care. So just because it's in the community doesn't mean it's the best standard of care when doing this comparison. So they added that kind of acknowledgement. And then Subdivision 2 is a new addition to the evaluation that the House added. If you could just scroll down a bit, please. Thank you. So this new addition would be comparing the mental health services among different Vermont correctional settings, including between men's and women's facilities, and also looking at how the services provided in Vermont correctional settings compares to the services received by those persons who are in the custody of the Department of Corrections who are incarcerated outside of the state. So kind of looking across the board at how the type of mental health services and how they're delivered and the frequency and timeliness of services. Next, in Subdivision 3, the addition of an assessment as to how the use of a for-profit entity providing these healthcare services affects the cost and quality of care in correctional settings. As you know, DOC contracts with an entity for healthcare services. So this is a look at how the nature of it being a for-profit entity impacts the services provided. And then
can I just, DOC uses all kinds of nonprofits too. So I don't understand this. This is, you know, the people that come in for, I believe it's Phoenix House they used to use. I don't know if they still do, but that's a nonprofit that comes into correctional facilities and provides mental health care. and group counseling. They use, kind of see this as kind of a, which healthcare services are they talking about? Mental health, or, because this is, I believe on the mental health side, they use both nonprofits and for-profits. Corrections.
I believe this is referring to the entity that they contract with that provides the predominant amount of healthcare services, some of which are mental health services, and the name of the contractor has slipped my mind. But
And no, I understand that. I'm just saying that when an assessment, when they use that term, that troubles me. Because they should be examining all.
Right.
This is about mental health, not about healthcare. So they should be examining an assessment of how the use of non-profit and for-profit entities, which whom the Department of Corrections contracts, affects the cost and quality of care in correctional settings.
If they're aiming this at the current one, why don't we just say how the use of the current entity?
Yeah, if that's what they're, I think I would just flag this as something that we would take out if we concur with further proposal.
Okay.
I don't see what good,
Well, I think the thought is that the current contractor is the way they operate, it doesn't give good services and it costs more than it should. And that's why they want to study it.
Yeah, but we just got rid of one, got another.
That's because we always get for-profit ones.
You're missing my,
I know, no, I get it.
no, my point is that we're contracting, the choices are to either contract for services or provide them through state employees. That's the issue.
It's also a question of whether or not the facilities being studied are in a state of flux right now. And I understand they want a comparison, but that comparison is going to be a snapshot in time that may not even be relevant by the time we get back in January.
Yeah.
I just flag this one if you would, Katie and Eric.
sure.
Yep.
The next subdivision that was added by the House asks for an assessment as to whether DMH should be providing oversight of the mental health services that are provided by the entity that DOC contracts with for healthcare services. So that's an addition. And then in subdivision 5,
I think you need to entities. Again, we're getting the same argument here.
okay, we'll flag that. And then in subdivision 5, the version that the Senate sent over asked for information as to how the MOU that DOC and DMH executed impacts the mental health services provided by the entity that the DOC contracts with for healthcare services. And the House added, and whether it is adequately addressing the needs of those with severe illness or in need of inpatient care.
Mhm.
So those are the changes to the kind of the contents of what's coming back in this report. And then a subsection C was added that, in the course of doing this work, the two departments are to ensure that social and racial equity issues are considered, including issues related to transgender and gender nonconforming persons.
Hmm.
So section 6, the forensic care working group, there were substantial changes there, and I have a side-by-side that might make it easier to kind of look
Okay.
at. So I'm suggesting maybe we skip ahead to section 7, and then I'll just switch documents to show you section 6.
Okay.
So if you could scroll down to 7, Eric, please.
Mhm.
Thank you. So this is a new section of the bill that the House sent over. This is an amendment to the existing creation of the Joint Legislative Justice Oversight Committee. This committee currently has 10 members, and this proposal would be to add 2 additional members for a total of 12 members. And that would mean that there'd be one additional senator at large for a total of 2 senators at large. And then the House member would be a member from the House Committee on Healthcare. And you'll see that change at the bottom. So on line 4, we have member appointed at large by the House, 2 members at large appointed by the Senate. And then at the very bottom of that section, line 8, we have the member from healthcare being added.
I would oppose this.
What's your thinking on this, Dick?
Well, I think, the Justice Oversight Committee works pretty well with 10 members. If the House wants to take their 1 member at large and use that for pick somebody from the Healthcare Committee, they can do that.
Wait, go back up, Katie, because I want to see the top here. Is it 6 members appointed by the,
Yeah, now.
Right now, it's 10 members.
and they want 6 and 6 and 1 member at large? So that's
There's
7.
1 member at large from both chambers.
Well, that's.
Right
so that's
now, there's
7.
1 at large from both chambers, and so they could choose somebody from the Healthcare Committee if they want. I think extending this committee to 12 members is problematic. I've been on this committee for a long time.
May I ask,
Yeah, go ahead.
what is the difference between having members from the House and an at-large person from the House? I don't get the at-large person. They're all at-large, aren't they?
No,
No.
there's some that are specifically from certain committees.
You have 1 from the Appropriations, 1 from Health and Welfare or House Committee on Healthcare, 1 from Judiciary, 1 from Institutions. And we've always had 1 at large, which would allow them to someone.
So
Yeah,
then, okay,
I agree with you, Dick. I think in general, the House prefers larger committees.
Yep.
And maybe that has to do with the fact that they work in large committees over there, but
Right.
I don't see why you would
I think-
make this any
Yeah.
bigger.
I think
I'll tell you
it
why
gets
they-
it gets unwieldy with the more members you have. And the Senate, we had a member last year who never showed up for a meeting. It was Senator McNeil. Never came to a meeting, not come to 1 meeting.
so can I just say, add one of the reasons I think they prefer larger committees with more members is because they have 150 and they need to spread the joy around.
Understood. I don't know if I'd call this one joy.
Well,
Anyway, I think this is something we should reject. If
Okay,
they want to change their at-large member to a member of the Healthcare Committee, they can do that. The Speaker has complete charge of that.
okay, let's flag this.
Yeah, I've noted that one too.
Okay. Did they say why they wanted it so big, or just to get the,
So I'm not always in the room when a bill is being discussed. My recollection, though, is when we look at section 6, there is a report that's coming to this committee that involves a forensic treatment facility. And there was a discussion that there was no designated expertise from House Healthcare that could weigh in on viewing that report.
Well, again, I would point out that if the Speaker wants to, she can appoint a member from that committee. The fact that she's failed to do so is not my fault. And go ahead, Katie, this isn't anything legislative. It's not your fault.
Why don't we take down this document and move to section 6? Okay. So I think you have to do a stop share, Eric.
Oh, I have the same document. Oh, do you
Oh, you
wanna-
do?
I
Okay.
think so. Is it?
Great.
I'll pull it up. Is this the one you're thinking of?
That's what I
Yeah.
was thinking of. Thank you.
Yeah.
Okay.
Yep.
So just to give you a little bit of context, when the bill left the Senate, you had created a forensic care working group. There are many elements that are the same and there are many additions. So I've tried to break this one section into different categories to walk you through what some of the different changes are. So the first category I have has to do with the working group membership. And then you'll see in the column as proposed by the House version adds additional members to this working group, including a representative of Dale, the Chief Superior Judge, a representative appointed by the Vermont Medical Society, a representative appointed by the Vermont Developmental Disabilities Council, 3 crime victim representatives versus the 2 that were proposed by the Senate, 3 individuals with lived experience of mental illness versus the 1 that was recommended by the Senate. And then the House language specified that these individuals with lived experience, at least one of whom has lived experience of the criminal justice or civil commitment systems or both, appointed by Vermont psychiatric survivors. And then the House version deletes one of the members that was proposed by the Senate, and that is a representative from BGS. So those are the changes to the membership.
This is whether you should build a facility, and I don't want a representative from BGS that does the building.
It will not fly well with the commissioner of BGS.
Doesn't fly well with me. I can accept having, the Chief Superior Judge, but shouldn't it be his or her designee? We don't
Right.
usually tell the judiciary who to appoint to a committee. I don't know if that's in the language or not, Katie, but.
I can't recall either.
Yeah, 'cause
My guess is that
I
it's
don't think we tell
Superior
the,
Judge.
I don't think we tell the judiciary who to appoint to committees. That's really in the purview of the judiciary. So could be Chief Superior Judge or his or her designee. Would probably be proper language. It's
Okay.
not in there.
I will
Because
find
you've
that.
given everybody else ability to. I don't have a huge problem with adding to the committee. I think it'll be unwieldy, and I don't know they'll get where they need yet. But
Okay.
I do think BGS needs to be there to discuss, because you're talking about building a mental health facility, but you're not dealing with a problem that's small but real in Vermont. Is we do not have a forensic capability, and if we're going to leave it to the Department of Corrections, and they deserve their own facility somewhere as a wing to one of their facilities for forensic patients, I think it's missing. And so I think that I agree with Senator Benning. There needs to be a member.
Okay. So the next category in this chart, but in section 6, your report looked at kind of the overlap in the mental health and criminal justice systems. That's kind of a broad way to describe it. And you had one report coming back November 1st of this year. And so the House restructured this reporting requirement. So there will be 2 preliminary reports. The first preliminary report comes February 1st of 2022. And then there's a second preliminary report that we'll look at in the next row when we change pages. That's specific to the question of whether there should be a forensic treatment facility. And then a final report on both of those issues is due January 1st, 2023. And the idea is that the final report is an opportunity to kind of fine tune the recommendations and work that was done in the preliminary report. So in terms of.
This is all going to be done by the group up above.
Yes. And you'll see that this group is, they're also going to be given in the House version the ability to have national experts weigh in and provide models to this group. So we'll get to that language. But in terms of exactly what this first preliminary report is looking at, a lot of the Senate language was used, but then there were additions, and I wanted to show you that. So I've put the House additions in italics so you could see where the Senate language was modified or added to. So first, the first thing that this report is going to be looking at hasn't changed since it left the Senate. Any gaps in the current mental health and criminal justice system structure. Next is opportunities to improve public safety, address treatment needs of individuals in the criminal justice system. The addition in the House was and consideration of victims' rights in the forensic care process. The Senate wanted to look at competency restoration models used in other states. And the House added including models that do not rely on involuntary medication and how cases where competency is not restored are addressed. The Senate version looked at models used in other states to assess public safety risks, including guilty but mentally ill verdicts in criminal cases. That was not changed. The House added due process requirements for defendants held without adjudication of a crime. They also added processes regarding other mental conditions affecting competence and sanity, such as intellectual disabilities, TBI, and dementia. The Senate version wanted the report to touch on models for forensic treatment, and the House added including inpatient, community-based, or other treatment models. And the House also left it open for any other recommendations. So again, this is part of the first preliminary report. And then if we scroll down to the second page, thank you. You'll see there's another column or another row that has to do with the forensic treatment facility. So this is the second preliminary report. And this comes about 6 months later, July 1st of 2022. So this is the report that comes in to Joint Legislative Justice Oversight Committee. And this committee specifies that based on the recommendations already submitted in the first preliminary report, DMH is to submit this second preliminary report as to whether a forensic facility is needed. So that is, and then if the second preliminary report does determine that such a facility is needed, it's in the final report that where we're going to have a recommendation as to the size, scope, and fiscal impacts of the facility. So it kind of has a tiered decision making. So in the first preliminary report, we're getting information about the overlap of the mental health and criminal justice systems. And the second preliminary report is a recommendation as to whether a forensic treatment facility is necessary. And if it is necessary, the final report is going to kind of fine tune all of the recommendations in the first two reports. And if that treatment facility is deemed necessary, provide recommendations as to what that facility should look like.
So by the time you built the facility, if you wait till 23 and you figure it takes 5 years for the state to build a facility, and in the meantime, we've built a new mental health facility without a forensic capability. This is ridiculous. I muted myself so I wouldn't be caught thinking something on that was not good. Again, you're just repeating this, and I realize you wrote it, but you're not, you're the legislative counsel. I'm not blaming you at all, Katie, but I need to know if we're gonna take the step that I believe is absolutely necessary, and that's building a forensic facility in Vermont. I would like this done sooner rather than later, and to think that this is going to be done sometime in 2023, adding 5 years is 2028. The Department of Corrections is being asked to deal with significant mental health issues that they shouldn't have to be dealing with. They're holding people because of a lack, and we know on detention, people with significant mental health issues last longer on detention. It increases those number of people in beds, and probably it's not appropriate for them to be there. And here we go on with the same old thing. And I feel a sense of urgency here. And I just don't think I want to wait until 2023 for a second preliminary report. Well, excuse me, for the final report. So I'm not, I don't know what to do with this section. I mean, they've got so much stuff in here.
Yeah.
It could take you till 2025 just to figure out what it is they're looking for.
May I ask a question, Senator Sears?
Sure, I'm just baffled.
When we are talking about building a forensic unit, we're not necessarily talking about it as a standalone unit, right? I mean, it could be part of, if, for
Could
example,
be part of a new mental health facility. It could be part of
Or-
a current corrections facility. It could be part of, the governor had the campus idea for different facilities.
yeah, so we're right now looking at, for example, building a new women's prison.
Yeah.
Why wouldn't they even consider, because that's a new building, why wouldn't they even be able to consider whether or not there could be a little L off the side of that or something with, I mean, we're doing going forward with projects now, and if we're not even going to make a decision until 2023, that seems, I agree with you.
For me, there's two problems. One is the victims of the various crimes that are being committed, and future victims, because we're not dealing with this population appropriately. It is very small. There's a very small population, luckily, but that population can do a lot of damage. The second problem is we're discussing building various facilities right now, both from mental health perspective as well as in the corrections. I just wanted to find out which department should be in charge of a forensic unit. In Massachusetts, I believe it's the Department of Corrections. It's the correctional facility in Bridgewater that has a wing for forensic cases. I believe that's, it may have changed, but this is years ago. And I think, that's what I was hoping they would look at. I didn't think it was rocket science, frankly. We lacked the capacity ever since Hurricane Irene, both for, the vast majority of people with mental illness do not commit crimes. They're actually more likely to have crimes committed against them. I understand all that, so I want to make clear to all those folks. But I am concerned about waiting and waiting and waiting. Sarah Squirrel, who's since resigned, was tearing down Woodside to build a new facility, mental health facility at that location. So, that was the plan. And if they do that, then it would be more appropriate to have a forensic unit there than at the new women's prison. If they do that, I think you're absolutely right, Senator White. This just doesn't make, I can't live with that. This part really bothers me.
Yeah, I don't get why would take so long. And
we already wasted a year. I mean, they didn't take this up last year. And so now we've got another year. We're almost at the end of the session. If all goes well, we're about 8 business days from adjournment.
you know what I'm going to suggest we do with this section?
What?
That we add the guiding principles, the experts, and the draft language section that are not in, that is in ours, the guiding
Yeah.
principles and the experts to ours, and get rid of all the rest of theirs.
Sounds like a plan. Would you help Katie with that?
Yes, I'd be happy to help.
Thank you.
Katie,
So-
can I ask a question? Section 7, that group is also considering all of this?
The section, sorry, so the only report that's going to the Joint Legislative Justice Oversight is this second preliminary report, which is whether or not there's a need for a forensic treatment facility. The other reports are coming in when the General Assembly is in session, so it goes to subject matter committees.
We're not gonna have time for S97 this morning, I don't think. I lost track of the time. It's already 20 minutes at 10 and we're on the floor at 10.
Oh,
But this has been helpful.
Yeah.
I apologize to those here on S97. And we'll try to get to that next week. That's not earth shattering. I just want to understand the proposals from Judge Grierson that's been added to S97, or the House is considering adding. I think it's fine. I understand that Judge Grierson and Marshall Call have been over. But there are people here who anybody want to comment on this draft of S3 that's here? Thank you so much, Eric and Katie, for the rundown. We really appreciate it. You could take the share down now, I think.
Sounds good. We'll do.
Thank you. Well, an opportunity to meet John Campbell and Evan. Is Evan still here?
I believe he is, Senator Sears.
Well, I just want to look at him so I know who he is. There, hi there. Evan. Nice to see you. Welcome to Senate Judiciary.
Well, thank you very much. It's nice to see all of you as well.
Yeah.
welcome.
So, Evan, why don't you, if we have a second, Senator Sears, I would like to comment one thing on S3, because there is that
Yep.
one section that I think is important as far as notification of the noncompliance. One part, and I think it needs to be worked, and I can understand Senator White's concern, but I think it has to be noted that it really doesn't allow us to really do anything. So it's the fact we're getting the notification, and I think that the idea was for us to, if we found information that somebody was not compliant and it rose to such a level, then we would be able to try to take some preventative measures, or to see what we could do to make sure that the person would become compliant. But however you want to go with that, we're fine. But I think that it's necessary for us to at least be advised if somebody is not being compliant and they have serious mental health issues that are put them as a danger to themselves or to the others in the community. So just would like to say that. And also just to introduce Evan. Evan, as you know, Pepper has left to take over the chairmanship of the Cannabis Commission, and we're very fortunate to have Evan have an interest in this role. And I'd like to turn it over to him, and he can kind of give you some of his background. So Evan, go ahead.
Sure. Thank you very much. Yeah, I'll briefly review where I came from. I graduated from Vermont Law School in 2008, and Hamilton College in Central New York before then. Spent 2 years in private practice at Paul Franklin Collins up in Burlington. And then after that, I did a 5-year stint in the criminal division of the Attorney General's office. I then went to the Office of Planning and Legal Assistance at the Agency of Natural Resources. Went back and did another 2-year stint in the criminal division of the Attorney General's office. And I just recently left my position of Associate General Counsel for the Natural Resources Board after 3 years there. And very happy to be on board with the department and to be working with your committee to the degree that I can be helpful in answering any questions. Please don't hesitate to reach out at any point in time.
Appreciate that. Are there any comments from either anyone who wants to comment on our comments on S3?
This
Areas
is,
where we, yeah.
So
Morning Fox and then Jack McCullough. And Judge, I think we can get to 97 tomorrow morning. I'll work on a revised agenda.
Senator, they're pretty technical. I mean, minor technical changes that I don't think the committee will have trouble with. I might have one more issue that I'd like to present to you tomorrow, and I'll fill you in on that. Thank you very much.
Commissioner Fox.
For the record, Morning Fox, Deputy Commissioner, Department of Mental Health. In regards to the language around orders of non-hospitalization and notification, it's been pretty consistent testimony on the House side, including crime victim advocates who had concerns about this language remaining in the bill as such, and that all supported having this as part of the study to take a look at. Part of the concerns, but from the department's end, are around the other notification pieces in this bill really provide minimal information from a protected health information type thing, but provide enough information to notify the attorneys and victims that a person's being released from a secure setting or from custody of the commissioner. This starts to get into the type of treatment and what a person is engaging in, which that really starts to move us into kind of that realm of what's protected health information and what should be provided. Also, some of the testimony that I've heard, as well as we've put forward, is what information does that do? I think, if you bring the folks back in from crime victims advocates, they were concerned that it can create some unnecessary angst or anxiety in victims that may not equate to anything. If a person misses an appointment or a person misses a single dose of a medication or something of that what's done with that information may not be actually very helpful and could actually be potentially re-traumatizing for a victim and such. We do think that folks who are on orders.
I want to say that we never had, it was never my intent to get information about somebody missing an appointment or missing a dosage. My intent was somebody who is completely bombed out, not going, not participating anymore, not doing anything, and who is becoming to the attention of neighbors, like the Pronto case, where bizarre behaviors occurring, but nobody's doing anything, and nobody knows until something serious happens. So it was never, and maybe we didn't make it clear. Maybe it needs to be clarified, but it was never my intent to know that somebody missed a dosage or missed an appointment or whatever. That certainly had nothing to do with it. So I just want to assure people that was not our intent. Our intent was that the person is it's the sort of thing that would result in a revocation of probation or parole, or where you'd have a hearing in front of a court because they weren't doing anything.
Right.
Or actually engaging in behavior that was harmful to themselves or others.
No, and I appreciate that, and I think it's similar to the process that one should look at when revoking someone's order of non-hospitalization.
Right.
That the revocation generally does not go forward because of a single dose, of missed medication or something.
Yeah, if we did, we'd have all of us would be.
That, if I can say, that was my huge concern with this, was because and I hate to say this, but if you have a therapist or a caseworker who really doesn't like the person at all, they could harass them and start, if they missed an appointment or if they missed a medication or if they didn't go to a class, that caseworker could wreak havoc in that person's life. And believe me, I've seen it happen in the probation system where PO doesn't
understand.
like the person and harasses them. So
I've
I
seen it
think-
happen as well. I'm not discounting that happened.
Right.
The question is, at what point does the behavior should be the state's attorney
Yep.
who, and the victim who believe the person is actively participating in treatment and are in the community. And at what point should they be aware that this person is no longer participating in treatment and is back to behaviors that are that are destructive to the community? And I mean, even if it's, you could argue if it's self-destructive, but when it's a danger to the community and others, then that really is where I was looking for, not that they missed a dose or they missed even 5 appointments.
Yeah, and I think that it's important. I think this piece is very important. I think that's why, you know, we appreciate having it in the study. I think it does need to be looked at, and you know, I would even offer to say to look at it, you know, earlier in our process of the reports or whatnot, because I think we also need to really be careful about who does that reporting. How does that happen? One of the basic tenets of treatment, when you're talking about mental health treatment, is the engagement of the individual with their treatment provider, and the basis of that engagement is based on trust. And so
we got about 5 minutes left of this hearing, and I would need to go to Jack, if you don't mind. If you wanted to, any other concerns, if you could let us know.
Sure. No, and just to get to Senator Nitka's question around competency and sanity evaluations and preservation of evidence. Competency, sanity evaluations are frequently ordered either competency or sanity or both currently. So that process won't change. As far as evidence go, generally they're collecting information as they go through their evaluation. And so I think what this really envisions is that they would then in some way, shape, or form have to hold on to any of that collateral information that they gathered during this time that could be used in the formulation of an opinion around their sanity.
Thank you, Commissioner. Jack? We can't hear you. Still can't hear you. There we go. Nope, still can't hear you.
Even though you're unmuted on the screen, we can't hear you.
Our computer's wonderful.
Fortunately, there's email, so.
Yeah.
Senator, while he's trying to get on, can I just say that we would not object in having this all being determined by a study, because I think there are things in there that would be better to really flesh out.
Well, yeah, that's helpful, John. I think for us, it's the dates of when the study would be due is more concerning. I understand that. I actually had a long conversation with Pepper before he left about that issue. And he expressed to me his concern of what would the state's attorney do with the information, even if they got it. So, you know, there's some good points there. So I'm okay with leaving that to study. I'm not okay with not finding out about it until 2023.
Well, we're there to help push it along as fast as possible.
No. Jack, we can come back. We'll be back here next week on this bill, I'm sure. And in the meantime, if you can get if you want to shoot us an email, that'd be fine. Thank you. Okay, thank you. I guess, committee, thank you very much. I sent you an email that we're going to meet next Wednesday and Friday.